Hello everyone, and thank you for joining me on a sunny day. So thank you very much. I hope you find this talk informative. It's about the Renters Reform Bill and the changes that are coming in. I'm Alice Harris, a Senior Associate in the Property Litigation team. I specialise in residential landlord and tenant matters, and I am able to help at the beginning of a tenancy by drafting tenancies, and also by at the end when we need to remove tenants in the eviction process, and everything that happens in between. Throughout this talk, I'll refer to the Renters Reform Bill as the bill, so I'd have to keep repeating it, but that's where we're going. And I think I better start the slides with a little bit of a disclaimer. Some landlords may find the contents of these slides shocking and disturbing, but I just wanted to let you know that the helpline, as in my contact details, will be provided at the end should anyone need any further support having watched this presentation. So I thought I'd just start with that disclaimer. So we'll move on to what we're going to cover. Joe, could you help me with the slide? Just getting the slide going. Sorry, everyone. So the Renters Reform Bill was brought in to implement the white paper that was released in June in 2022, which was to give the intention was to create a fairer private rented sector. It's very tenant friendly, and they really want to give tenants a better deal. That's what they're suggesting. And oh, sorry, gone a bit too quick there. So they're trying to level up the quality of housing in all parts of the country so that everyone can live somewhere that is decent, safe and secure, and a place they're truly proud to call their home. So it's basically Michael Gove trying to say tenants have what they perceive as having a raw deal, and this is in order to try and bring them into a leveler playing field with landlords. The bill demonstrates the government's aims to assist renters and give them a greater deal of security and a better deal, but landlords will often see that as them getting a rougher deal. And this is the point of the talk today, to give you an idea of what is the impact is going to be for landlords, and also the benefits for tenants. So today, this is what we'll cover. The first part of the bill is about tenancy reform, and all the major changes are basically included in this section. So the removal of fixed term tenancies, tenant notices, and the big one, the main heading, abolishing of section 21, no fault evictions. We've got possession grounds, the amendment and the addition. We've got statement of terms, rent increases, and also pets. Then we've got part 2 of the bill, which is about residential landlords and the system changing between the system and how it works with the relationship between the landlord and the tenant and the options that they have. And then I'll look at some slight other considerations about student lettings and also the EPC, gas safety and how to rent. And then we'll talk about when this is all going to come into play. So the bill itself is quite far-reaching, so there is things in there that I will not be able to cover, such as today I will not be covering social housing, purpose-built student accommodation or agricultural tenancies. Some of those are mentioned in the possession grounds that I will talk about later, but we're not going to go into detail on those. So if you are interested in any of those elements of the bill, then you can contact me later and we can see where we can go from there. There are also things that were mentioned in the white paper that the government talked about bringing in, but they've never made it to fruition in the actual bill. They've not made an appearance. And some of these potentially are good things for landlords, such as lifetime deposits were talked about in the white paper, that it would be almost like a passport of a deposit that you can move from tenancy to tenancy. That hasn't made it made an appearance in the bill. You've also got the decent home standards, which currently applies to social housing, and the white paper indicated that they want to apply it across the private sector, but it hasn't come in. The bill doesn't talk about it. It doesn't mention it. The explanatory notes given by the government in addition to the bill suggest that the government are still trying to work out how to bring this into the private sector. So I think they know it's going to be a big shake-up when they do bring it in. So they're just trying to think it through now as to how they can deal with that. Also, the white paper indicated that there would be a prohibition on blanket bans for landlords to not let children or those on benefits. But again, there's been no prohibition in the bill. So those are things that are likely to come in at a later stage. They may be brought in during the discussions at the moment, but they're not there at the moment. The bill has got a long way to go. So what I'm talking about today is the current status of the bill, how it's worded and what is included. But you should bear in mind that there are plenty of opportunities when it's going through discussion in the House of Lords and the House of Commons that things will be added in, taken away and modified. So it is a work in progress. So no doubt we'll get changes that we need to be aware of. But the advice given today is on the basis of where we're at currently with the bill and its wording. Okay, so let's move on to clause 1. This is the removal of fixed term tenancies. The bill is now making all tenancies periodic. You will no longer be able to fix a term. And the periodic nature of those tenancies will be on a monthly basis, but you can do, or no longer than a 28-day period. They will now be referred to as assured tenancies, no longer assured short hold tenancies. So we have to start changing our abbreviations and stop using AST and use AT instead. And if a landlord tries to purport to fix the term in some way, that clause in the agreement will have no legal effect. It'll be null and void and the tenancy will be periodic. So you cannot contract out of this. You cannot give a fixed term. There is only one carve out of that, and that is any tenancies which are over 7 years in a period. They're not assured tenancies. They will take themselves out of this regime. So that's something to be aware of. The aim of periodic tenancies is to give tenants more flexibility. So tenants can then potentially stay longer because they're not subject to Section 21 notices being served on them when the landlord requires. And also it gives the tenants the flexibility to terminate those tenancies when the tenants want to. And we'll go on to that in a minute and they can do that. But it's potentially where the property is not quite right for them. They don't want to be, they're not then fixed into a 12-month, 2-year term. And also where properties are poor quality or the landlord is not providing a good service or meeting the obligations. So it can be where there's just a falling out and they're not happy. This gives them the opportunity to get out. So when this will come in is coming in 2 phases. So 6 months after the implementation date of the Act, all new tenancies will be periodic and covered by the new regime. And then 12 months after the implementation date, all tenancies will be periodic. So there will be a period of transition between current tenancies, new tenancies, and then all tenancies. But I'll cover that in a bit further detail. So tenants' notices, this is a complete shift in where we are currently. At the moment, a landlord can terminate on 2 months' notice after the expiry of the fixed term by serving a Section 21 notice. That has now gone, and it is a role reversal, and the tenant can now serve a 2-month notice to terminate a tenancy. And that tenant can serve the notice at any time. And therefore, they can take on a letting and serve a 2-month notice immediately, therefore making arguably the tenancy a very short 2-month one. So this might come into play where tenants are looking to potentially be seasonal, where they're going, what they're doing, are they working for a short period of time? Well, now they can take on an AST and terminate it after 2 months. You might look at holiday places where people decide, actually, I want to live in the summer, I want to go down to Cornwall, I will take in a tenancy and then I'll terminate it when I don't want it anymore. So that's something that we're going to need to see and work on, because tenants are able to pick and choose where they are and how long they're there for. A tenant's notice must expire at the end of a period of a tenancy. It must be in writing and it cannot be withdrawn without the landlord's agreement. So once the tenant serves it, that's it. The landlord can rely on it or they can agree to withdraw it. Parties can also agree a shorter period. So if the landlord's happy for them to go out after a month, they can do that. What the landlord can't do is prescribe the form of notice that the tenant must give to the landlord to give that 2 months notice. So you can't specifically make it hard for them. You can't say it has to be an exact form. You can't say it has to be given and served. You know, it's going to be more flexible and tenants have the option to serve the notice how they wish rather than in a format the landlord wants. So that demonstrates the government's intention for the tenants to have more flexibility. It's the tenants who can terminate on 2 months rather than the landlords. So it essentially there is the landlord is going to have less certainty as to how long those tenants are going to be in situ. Some may stay in situ under the periodic tenancies for some time, but there is always the risk there that the tenant can turn around and give 2 months, which potentially doesn't crop up as much now. So this is what I would call the headline act of the bill: the abolishing of the Section 21 notices, the end of no-fault evictions. This is a major concern for landlords and agents that I'm aware of after talking to them about the bill coming in. Section 21 notices give landlords flexibility, as I've just explained, but they're removing that and basically saying, no, you cannot do that anymore. You cannot just decide because you want to, you can give a 2-month notice to get them out. And at the moment, it's the most commonly used eviction process. And over the years, the process has been subject to many changes. You've now got to comply with the deposit regulations, the gas safety, the how to rent, and the EPC. So they've changed and tweaked it a lot to try and make it harder for landlords to be more stringent about using it. And now they've just gone the whole hog and gone, no, you're not allowed to use it anymore. So now the landlords can only use the Section 8 process, which is under grounds of Section 8 of the Housing Act 1988. And that is under a new form of Section 8 notice. So it will be in a prescribed form that has to be filled out correctly to ensure that notice is given. In order to help landlords in just relying in the Section 8 notice, the government have gone in the bill to add new possession grounds, modify old ones to try and balance taking away the flexibility to terminate with giving them potentially more grounds upon which they can rely on to terminate. And what the bill says about why it has abolished the Section 21 notices, to quote them, is to say to level the playing field between landlord and tenant, empowering tenants to challenge poor practice and unjustified rent increases, as well as incentivising landlords to engage in resolving issues. So what their aim is to try and get the parties to work together. Rather than the tenant raising a problem and the landlord serving a Section 21 notice in response, they're trying to get it to be a bit more of a collaborative experience. And the tenant raises a problem, the landlord then has to address it because they can't just get them out. It's not an easy fix. When is this coming in? This is probably the main thing people want to know about. It's coming in phases again, as with the fixed term and the periodic tenancies. The first phase is 6 months after implementation. All new tenancies will not be able to serve as Section 21. And then at least 12 months after the implementation date, all tenancies will not be able to serve a Section 21 notice. So, you know, it's a big change and a big shift, but the government have tried to balance it with the introduction of new grounds, and that's where we'll go now. Bear with me. Right, so these are the possession grounds. Just to explain the colours in the table, I've not just done it to keep you awake and interested, but the red wording is where it's an existing ground, but amendments or modifications have been changed. And then the yellow grounds are brand new under the bill. So these have purely been introduced. So most landlords will be aware of just the grounds being mandatory or discretionary. And that's quite important here, because if you get a mandatory ground that you can rely upon, as long as you satisfy the criteria, the court have no discretion and you can get that possession order at court. Whereas the discretionary grounds, you have to persuade the court to give you the possession order. So it's always better to be able to rely on mandatory grounds than it is on discretionary. And also, it is possible to rely on multiple grounds. So what we tend to do at the moment where we have rent arrears is we rely on the ground Section 8, if there's 2 months at least rent arrears when the notice is served. And then we couple it with ground 10 and 11, which are about there being some rent arrears and a persistent delay in paying rent. So when you couple them together, you try and strengthen your notice in case one of the grounds falls away, you can then rely on the others. So it is often good to stack the grounds you can rely upon, but as many as you can in, if you can. It might be you only fit under one of them, but if you've got any other options, you can stack them. So ground 1, this is relation to occupation by a landlord or the landlord's family member. So in summary, the landlord or their close family member wishes to move into the property. If you can fulfill this ground, you can serve a Section 8 notice in which to terminate the tenancy. It's on a 2-month notice period. Previously, the ground was there, but it could only be used if a landlord or their spouse wanted to move in, or civil partner living like a spouse. What they've done now is they've cast the net wider and allowed it to include family members, which are parents, grandparents, siblings, children, grandchildren, spouses, grandchildren, sibling, you know, it's a bigger family network that can be relied upon. So that potentially will open up that ground a lot wider and have a wider application for landlords saying, actually, I want it for my parents to go in there, they need to live in there now, or actually my son's back from uni, I now want them to go into a property. So that's there. Also, you don't need to give advance notice of this ground anymore. Under the current rules, you used to have to give them a notice in the tenancy agreement or before it if you wanted to say, well, we might need to move back in. You don't need to do that anymore. The advance notice requirement has gone. The one thing that the bill doesn't do is tell us what information is needed to show that evidence that the landlord's family member is going to move in. There's no indication as to what intent is needed. Do you need to have got them signed up to a tenancy agreement ready to move in, or is it just because they've indicated they want to and you'd like to? So it is open to abuse here. There may be some landlords out there who try and use it to say, oh, well, yes, my son wants to move in. So what they've done now is given the local authority power to enforce it if you misuse it. And they say you misuse it if a landlord relets the property within 3 months of the tenant moving out and not allowing that family member to move in. So if you say my son's going to move in, the tenant moves out, and then you relet it a month later, you're in breach, and the local authority can fine you between £5,000 to £30,000. So they're trying to give it some teeth. They're trying to deter landlords from using this as a weapon against tenants by just saying, oh, well, we're happy to move in. Although what I would say about that is the local authority are not going to know about all of these tenancies and Section 8 notices being served on this ground. So the only way the local authority is going to know is if the tenants report it. And at the moment, that involves the tenant wanting to be incredibly proactive in keeping an eye on what happens to the property after they move out. Most tenants move out, they move on. But here, it's almost relying on the tenants keeping an eye, or that landlord wanted to get me out because their son wanted to move in. Oh, the son hasn't moved in, they've relet it, so I'm going to report them to the local authority. So I think there may be scope here that the government are trying to potentially incentivize tenants to keep an eye on what landlords are doing and then report them to the local authority. And I wondered if there's scope there for potentially compensation, there being some provision that compensation is claimable by a tenant if a landlord wrongfully uses a ground, for example. Or such as rent repayment orders. If a landlord doesn't have an HMO license, a rent repayment order could be applied for by the tenant to get up to 12 months rent back while the license isn't in place. So I wonder if something like that is going to come in to give tenants the incentive to report to the local authority. Otherwise, although the local authority have teeth, they don't have sight, they don't have vision of it. So that's something that we need to bear in mind. But we'll have to wait and see what they do about that one. And then ground A is the sale of a house. This is brand new, meaning if landlords want to sell, they can use the ground, they can get the tenants out on 2 months' notice. Again, it can't be, sorry, what I should have said about the family member one, you can't use it in the first 6 months of a new tenancy. And that's the same with the sale of a house. You cannot use it in the first 6 months of a tenancy. And again, there's nothing in the bill talking about what evidence you need to give as to your intention to sell. So if does a landlord have to get to exchange? Does a landlord have to have an agreement with an estate agent? Or, you know, how far down the line of that intention do we have to get to be able to serve the notice? That's not clear. And we'll have to wait and see if further clarification is given as the bill is discussed further. And again, the landlord cannot relet within 3 months after the date of the Section 8 notice. So if you say you're going to sell, you serve the Section 8 and then you don't sell, there is an element you can be fined there from the local authority of up to £5,000 or be liable for a criminal conviction. But again, this relies on the local authority being told by the tenants that this is going on. So again, it's potentially tenants policing this and whether they become alive to the fact that they need to or want to do that. Okay, so this is ground B, 1B, sale under a rent to buy, which is in relation to social housing. This is a new ground. The tenancy must have been entered into pursuant to a rent to buy agreement. So that'll be applicable, and it's a 2-month notice. Then ground 2, sale by mortgagee, is an existing ground. It's where a lender wishes to sell the property, but the changes they've made to this are that the mortgage doesn't now need to predate the tenancy. So at the moment, you could only rely on that ground if the mortgage was in place before the tenancy commenced. But under the bill, you can rely on that ground whether the mortgage was granted into before or after the tenancy commenced. And again, a landlord cannot relet within 3 months of the surrender. So again, it's trying to give teeth to the fact that landlords should not misuse these grounds. So these 2 grounds are brand new. They are in relation to superior leases and superior possession by landlord, and they are in relation to social housing landlords, in relation to when and why they might need to get a property back in a social housing context where there's a superior lease. So although these don't apply to private landlords, it does raise an interesting point though, especially ground 2ZB, for private landlords where they are subject to a superior lease and a landlord themselves. So where you have a leasehold property and you have a superior lease, at the moment, if your superior lease requires you to remove the tenant, your AST tenant from underneath you, you can rely on the Section 21 grounds to get them out because your superior lease requires you to act. You serve a Section 21, 2 months notice, and you can take action to get rid of them. However, on the removal of the Section 21 notice, there are no Section 8 grounds that cover this point where there's a superior landlord in a private rented property. So you may find yourself in the situation, if none of the other grounds apply, you may find yourself with a tenant that you can't rely on a ground to get them out, but you're technically in breach of your superior lease. So I wonder whether this is going to be subject to more scrutiny as it goes through, but that is something to keep an eye on if you are a landlord with a superior lease that affects you. Okay, so 1 ground has been completely removed, and that's the ground in relation to holiday let. So that's just gone. So we can forget about that from when the bill comes in. And ground 4, student accommodation. In the 12 months prior to the start of the tenancy, the property was used to house students, can only be used where specific exempted educational establishments. So again, this is for purpose-built student accommodation, universities, colleges, not private student houses. And I'll come on to that later. So the only change in that is that notice to rely on that ground must be set out in the written terms of the tenancy, which again, I'll deal with later. And the same ground 5, ministers of religion, property needed for ministers of religion. It's an existing ground. The only change is that notice to rely on that ground must be set out in the written terms, which is essentially going to be the tenancy agreement. So I'll move on to the next one. Sorry, this is a bit of a whistle-stop tour. So ground 5A, agricultural workers. This allows landlords to seek possession of a house for someone who's employed by them as an agricultural worker. And agriculture is defined by Section 1 of the Rent Agricultural Act. So if you are looking at agricultural employees and workers, then this may be a ground that you can rely upon, and it provides for you to give 2 months notice. And ground 5B is again a new ground for new employees, but this is for social landlords only, and it's 2 months notice required to be given on that one. There we go. Right. Ground E and ground 5F are about supported accommodation, both used for social housing. So not applicable to, I'm not going to cover it in detail in this talk, but they are, just to be aware, they are there. And also, obviously, if you do have a property that is let for supported accommodation, then you can look to use these grounds. Ground 5G, tenancy granted for homelessness duty, again, mostly aimed at local authorities and social housing. However, it could apply to private landlords if they granted the tenancy to to allow the local authority to fulfil their homelessness duty. And that is a 4-week notice period on that one. Redevelopment. So again, this is an existing ground, but what they've done is they have opened it up slightly. It's where a landlord wishes to demolish or substantially redevelop the property, which cannot be done with the tenant in situ. So I wonder whether landlords are going to start to think a bit more outside the box as to what they want to do with their property. Do they want to extend? Do they want to renovate it? And whether that then can be used as a ground to say, well, actually, I want to end the tenancy under this level. It can apply to private landlords. It can't be used in the first 6 months of a new tenancy. But it's also removed the need for the landlord to have had the property interest pre-tenancy. So previously, to rely on this ground, you had to have been the landlord and the owner in the property interest before you granted the tenancy. But now, technically, if the tenancy, if you purchase a property with a tenant already in situ, you can still rely on this ground, although it would have to be after the first 6 months of that tenancy. So if you were a relatively new tenant, you'd have to wait. But technically, you can buy in and then look to redevelop, which was something you couldn't do before. And it's a 2 month notice period. But again, with this, it's about intention. What does a landlord have to show to say that it wishes to demolish and redevelop the property? There is nothing in the Act which helps that. It's potentially akin to the Landlord and Tenant Act 1954 for commercial premises, where a landlord has to show a genuine intention to redevelop and be able to demonstrate that with like potentially planning permission or something. But again, the bill does not specify. So I think it's open to abuse by landlords, and further clarification is needed in order to be able to work out how this one exactly works and how landlords can rely upon it. And again, because you can't, the local authority can't get scope on everything and what all the notices are doing, it again relies on the local authority to report any misuse of this ground. So again, incentivising tenants to potentially raise this as a problem. So ground 6A is a new ground entered into, introduced by the bill about enforcement action. And I think this is a very good ground, and it probably should have been introduced earlier in my opinion. It's where a landlord is subject to enforcement action and needs to regain possession to become compliant. Because at the moment, if you're subject to enforcement action by the local authority, and for some reason you can't rely on a section 21, or there's no rent arrears to enable you to rely on a section, ground 8, so section 8 notice, then you're a bit stuck, and you might be, the local authority might be trying to take an action for you for being in breach, yet you still got the tenants in there. So this ground should open up a line for landlords who find themselves in the unfortunate position of being subject to enforcement action to be able to rely on that action to say, well, actually, I need to get the tenants out so I can carry out remedial action. And it covers things like banning orders, improvement notices, prohibition orders, HMO licenses being refused and revoked, and HMO licenses being breached. So say you've got a license for 5 people in the property, but you're currently letting it to 6, that would be a breach. They could be taking enforcement action against you. You can use this notice to give tenants 2 months notice to get them out. So again, I think that is a useful ground. Obviously, if you find yourself in a position with enforcement action to be taken against you, it's not ideal, but at least this will then give you the remedy to fix it and sort it out. Ground 7, death of a tenant. This is an existing ground where you have to commence possession proceedings begin no later than 24 months after death. This has extended the period of knowledge. It used to be 12 months and it's now 24. And I think they've done that to give a greater period of time for people to assess and analyse when someone has died, which potentially sounds silly. If you've only got a couple of properties, you're probably well aware of whether your tenants are still there or not. But when you've got a landlord with an estate with a large property portfolio, with less visibility of their tenants, this gives them the time for that information to filter through and enable them to still take action on that. Ground 7A is about antisocial behaviour and criminal behaviour. It's an existing ground. The tenant has been convicted of a specified criminal offence or has breached a relevant order put in place to prevent antisocial behaviour. The changes to this one is there are no notice period. So if you've got a tenant and you satisfy this ground, you can immediately go off to court and get possession. You do still have to give notice to the tenant that you have done that, but you don't have to give them advance notice. And what they've said is one of the restrictions they've brought in, which makes me laugh slightly, is that no possession order must be given within 14 days of the notice to the tenant that you've commenced proceedings. And the reason it makes me smile slightly is I would like to know which court the government think you could go to in order to get a possession order within 14 days, because I would very much like to issue in that court regularly. So yeah, it's a bit unlikely, but they've just put that in there to give a bit of a buffer that although you can apply immediately, you might still need to wait in order to get them out, but a 14-day period. But if you get a possession order within that time, you're incredibly lucky. So that's where that one's come on in. And then what we're looking at, ground 8. This is probably the ground that most landlords and agents are aware of in relation to Section 8 notices. Rent arrears, where the tenant has at least 2 months rent arrears both at the time the notice is served and at the time of the possession hearing. This is the ground that we use regularly. It's the most commonly used ground when you couple it with 10 and 11, which will come up on the next slide. The one big thing that they've done in relation to this is change the notice period. It's no longer a 2-week notice period. They've extended it to 4 weeks. So this used to be the quick option. If they were in arrears, you can serve notice and you can apply to court and get them out. But now they've extended that to a month. So that's just more time where the tenant is in rent arrears, where the landlord has to sit and wait before they can start commencing proceedings. So that's something that's a bit unfortunate. And the other thing they've brought in is that if rent is missed due to a universal credit payment coming in at the end of the month, this is discounted for calculation of arrears purposes. So you can't include them in the arrears calculation if they're going to be coming in at the end of the month. So that's something that they've tried to bring in, because I think they're fully aware of the problem with the universal credit and when it gets paid and how it gets paid. Ground 8A, brand new ground, and I like this ground because it helps support ground 8. It's where a tenant has been in at least 2 months rent arrears at least 3 times in the last 3 years. So I think the aim of this ground is to catch those tenants who are dipping below the 2-month rent arrears to protect them from a Section 8 notice. So say you serve a notice and they then pay off the arrears, so they're only 1 month in arrears. A landlord under ground 8 would be not able to satisfy the mandatory ground at the date of the hearing if the arrears were less. So this is just to give landlords a bit more scope to get tenants out where their rent arrears are dipping and coming up, dipping and coming up. But one thing I would say about this is that it's over a 3-year period, which is quite substantial, especially given that that 3-year period at the moment covers COVID. And there are no doubt lots and lots of tenants who over the last 3-year period have fallen below 2 months rent and then picked back up again, and may have done it a couple of times. If so, they are then caught and they can then use this as a ground in which to get them out. So I think that's quite far reaching and will capture quite a lot of tenants. So I wonder whether they're going to amend that 3-year period as they go through discussions in the House. So again, that's a kind of wait and see. It might be reduced, it might not. So that's something. But again, that's a 4-week notice period. Okay, so we're now on to discretionary grounds. These are ones where you've just got to hope you can persuade a court to give you the possession order when you've satisfied them. Ground 10 and 11. So ground 10 is the tenant is in any amount of arrears, or 11, the tenant has persistently delayed in paying their rent. And again, the notice period has been extended to 4 weeks from 2 weeks. So these are grounds that are often coupled with ground 8, and I assume will soon be coupled with ground 8 and ground 8A. To cover off if they suddenly don't satisfy the mandatory criteria, they can rely on this discretionary ground. Ground 14, antisocial behaviour, is a tenant or anyone living in or visiting the property has been guilty of behaviour causing or capable of causing nuisance or annoyance to the landlord or anyone living in or in the locality. So this is to capture those problem tenants where they're causing problems. They are nuisance and causing annoyance to you, your neighbours, and just generally causing you problems. The changes to this notice ground are that the wording used to be the tenant had to be likely to cause nuisance annoyance, whereas now it's changed to capable of causing, which is a different criteria, and potentially a criteria that a landlord may be able to say is satisfied easier than saying, well, they're likely to do it. Well, actually, they're just capable of doing it. I know what they're like. They're capable of doing it. So again, that's one to watch. And then the notice period, it is an immediate. You don't have to give any notice. You can go straight to court. But again, they've put in the caveat saying no possession order within 14 days of that notice if you telling the tenant you've gone to court. But again, I would like to see any court process a claim and give a possession order within 14 days, because unfortunately, it's just not happening at the moment. So the grounds I've just talked about are the ones that are new or have been modified. The grounds set out on this slide are those that are the current grounds and have been unchanged. So you've got the mandatory ground of a right to rent, meaning no right to rent, so the tenant or at least one of them has no right to rent under immigration law, 2 weeks notice you can serve. Then you've got the discretionary grounds that the landlord can offer suitable alternative accommodation under ground 9. Again, that's a 2 months notice. And then you've got the ones about deterioration of the property, ground 13, or deterioration of the furniture, ground 15. So if the tenant is not living in a way which is helping or is causing the property to deteriorate, you can rely on ground 13, potentially ground 15 as well, give 2 weeks notice, and then give as much evidence as you can to the court to try and persuade them that these grounds are satisfied and that you can get out. We've got the domestic abuse, that's for a social landlord, they can use that ground. And the rioting ground came in a lot when all the riots occurred, but it doesn't really feature too much anymore, but it's there if you need to use it. And the false statement, so if a tenant has misled you in granting the tenancy, you can use that. And then you've got the supported accommodation ground, which can be used where the tenant is refusing to engage in the supported accommodation, and that's a 4-week notice period. So you can see after that very whistle-stop tour of all the notice grounds that there are a lot of grounds to use, but what you'll have to make sure of is that you can shoehorn your situation into one of them, which might be where it's difficult. So I've just been asked a question on Section 8 grounds. Would the ground cover general service occupancies? See, I think general service occupancies are slightly different because arguably they would fall outside of the sphere of this regime. But again, it's something that would need to look at the bill in greater detail with regards to agricultural tenancy. So if that's a concern of yours, then drop me an email and I can look into that into a bit greater detail. But service occupancy agreements don't fall into the AST sphere at the moment, which leading to believe they're not intended to also fall into the assured tenancy scheme under this regime. So, right. Okay, so at the moment we use Section 8 notices as almost like an escape route. A landlord can use a Section 8 notice when they haven't really done the gas safety, haven't done the EPC, and also haven't done the tenancy deposit requirements. However, the government have caught on to that, I think, and now they've changed it completely. They now need you to comply with the tenancy deposit requirements before you serve a Section 8 notice. So it's giving you that tick box list to say, have you done, registered the deposit, complied with the initial requirements and given the prescribed information? You must be able to tick all of those before you can serve a Section 8. And if you can't tick them, then you have to remedy it by returning the deposit or agreeing deductions. So it's bringing in the tenancy deposit requirements from Section 1 to 21 and just porting them across to the Section 8 notices. There is one exemption which I've found so far. That's a deposit compliance is not required where tenancies were created on or before the 6th of April 2007, but that's because that was the date that the deposit requirements for you to register and deal with the deposit scheme came into play. So where it's an older tenancy, you don't need to have complied with it in order to be able to serve Section 8. You also don't need to comply with it in relation to antisocial behaviour grounds, so ground 14 and 7A. So that's still an option. The deposit requirement grounds are set out in Section 213, but I'm sure you're familiar with them. Register the deposit within 30 days, comply with the scheme's initial requirements, and give the prescribed information to the tenant. You can give the prescribed information late, but if you haven't even registered the deposit or given it, then you have to give it back or agree directions before you can proceed. Sorry, give it back to the tenant or agree deductions before you can proceed. So again, that is now giving that landlords, imposing a hoop that the landlords have to jump through for a Section 8 notice that they didn't previously. So that's something to be aware of. So you need to get your ducks in a line with your deposit at the beginning of the tenancy to ensure Section 8 notices are open to you. Rent increases. This is another one that potentially may concern landlords. And this is that there are now statutory procedure as to how you increase rent and how rent is challenged by a tenant. You can now only increase the rent via a Section 13 notice. I should just say here that there are tenancies for social housing which are going to be called low cost tenancies, which have got different rent increase regimes, but they're outside the scope of this talk today. You can also only increase the rent once a year, which some landlords might not like, some landlords will think that's acceptable. So it depends on the market and your type of property. The rent increase notice period is also gone from 1 month to 2 months. So the tenant will have a greater notice period in which before the new rent can come in. And I think the aim of this is to prevent retaliatory evictions, retaliatory rent increases, where the tenant raises concerns, the tenant is slightly difficult for some reason, or they just don't get on with the landlord. The landlord will then say, right, I'm going to increase your rent, and the tenant then has to stomach it, or they move out. Whereas if they try and regulate it, they're stopping landlords from using rent as a mechanism in which to get the tenants out of the property. The one thing that I find incredibly interesting is that a tenant can challenge rent within the first 6 months of a tenancy. So a tenant can go into a new tenancy and know what the rent is, but then challenge it anyway. And that to me is quite wide-reaching, because you might get a tenant who really likes a property, doesn't quite want to pay the high rent, goes into it, agrees the tenancy, and then challenges the rent to see if they can get it any lower. So yeah, that's one thing to be aware of, and that potentially is aimed to try and stop landlords from hiking the rent too high at the beginning. You might not get tenants in the first couple of months, first 6 months, first year, challenging these rent increases, but as tenants become more aware of what they can do in their rights, they're more likely to do these challenges. So that's something to be aware of. They can also challenge after a Section 13 notice has been provided on them, and any challenge on rent goes to the first tier tribunal in the property chamber. And also the property chamber can backdate rent increases on challenges if they need to. I think rents could really vary. I think it's really hard to tell what's going to happen in the market when this bill comes in. Landlords potentially, because they know they can only increase once a year and they're tied in for longer periods, might therefore have higher rents at the beginning. Also, the market might shrink. Landlords might not be happy with these new changes, might not want to not be able to get out on 2 months' notice, and so leave the market, making the market smaller, making it more competitive, meaning rents can be increased. So it's, there is potentially some glimmer of hope there that higher rents will be received, but again, it's just seeing how this impact does and what landlords do, whether they decide to leave the market before it comes in or give it a try and see what happens. So we will just have to see in that regard. Okay, so statement of terms and information is brought in by clause 9 of the bill. This is where a landlord must provide a tenant with a written statement of terms on or before the first day of the tenancy. And I know most of you on the talk are probably thinking, well, that's pretty obvious. We do a tenancy agreement, which is fine. And that can include all the terms you need it to. But there are some landlords out there who are happy to let tenancies on an oral tenancy. That's not going to be allowed anymore. You're going to have to give them certain information set out at the beginning of a tenancy on or before they go into occupation. And you also have to give notice of any notice-based grounds that you're going to want to rely on, which is the 1B, 2ZA, which is set out on the slide. There may be further requirements introduced in relation to this from the Secretary of State, but we'll have to see. And again, if you don't comply with this, the local authority can fine you up to £5,000 for not giving this statement. Okay, so this is my favourite slide, just because I think the picture is really quite cute. Pets. This has been introduced by the government because they're conscious of the increase in pets since COVID. And one source tells me from my research that 24% of all pet owners acquired their pet in the last 2 years, meaning that there is 5.4 million pets been acquired since the beginning of COVID, which is quite an increase in pet acquisition. But there's also been a development in urban areas and the increase in flats, meaning landlords are less likely to want pets in those type of areas. So the government brought in the ability for a tenant to ask for to be able to have a pet under the tenancy, and the landlord can now not unreasonably withhold the consent. So the landlord has to be reasonable in considering that request, and it's an implied term that will go into all tenancies. So it doesn't even need to be written in the terms. A tenant can ask for a pet and the landlord has to reasonably consider that request. The request must be in writing and give a description of the pet. So it can't really just, if it just says cat, then the landlord can turn around and ask for further information. Is it one of these Mancoon house cats or is it a normal moggy? The landlord is entitled to ask for some questions. And the landlord must also respond within 42 days, which is 6 weeks, in writing. That to me is a very long period of time for a landlord to decide whether it's happy for a pet to be in its property. And I think it's open to misuse or potentially clever use by landlords as to how you want to term it, as to whether landlords seek to use this time to find new tenants who don't have pets. because that's potential that they could do that within 6 weeks, sorry. So that potentially is something we need to be aware of. And it's also unclear from the bill as what would constitute unreasonably withholding consent. And that needs some further clarification. So what grounds can a landlord be deemed to be reasonable to say no to a pet? And it might be that there's a danger in it, or the type of property doesn't lend itself. Say it's a 1-bedroom flat and they want to get a giant Great Dane in there. I don't know. At the moment, the bill does not help us with that, but that's something that we might get further clarification or guidance from. And where a tenant has asked for the pet and the landlord has given their consent reasonably, the landlord can either require the tenant to undertake to obtain its own pet insurance to cover the pet and any damage it may cause, or the landlord can take out that pet insurance and require the premium to be paid by the tenant. So that is something that the tenants are potentially going to have to pay for to have that privilege. And some of you eagle-eyed people there may realise that this potentially requesting a payment of an insurance premium may be seen as a breach of the Tenants' Fees Act. Well, it's likely to become an exception under the Act. So it is likely to be a permitted payment under the Act in order to be able to allow landlords to challenge it. And again, a landlord could look to get a premium. Normally you get a policy for a year. Tenant may be required to pay that premium for a year, but essentially the tenant pet might only be in there for 6 months if the tenant is only in there for 6 months. But the bill will allow the landlord to recover the full premium from them. So that one's that. I'm conscious of time, I don't want to keep you going. So this is only a short one. This is just to give you a bit of a flag that the government are trying to crack down on unlawful evictions and harassment of tenants. So they've given the local authority to fine up to £30,000 for unlawful evictions. But if you have been fined, you can't then be subject to a criminal offence. So it's one or the other. But that's just to give you an idea that the local authority are given a bit more teeth in that regard. Now moving on to chapter 2, part 2 of the bill, Landlord Redress Scheme. This is the creation of a new ombudsman. Landlords will be required to sign up to this and pay for membership, although we don't know how much at the moment. And failure to register could result in a fine of up to £5,000. So you just need to be aware that you're going to need to sign up to this. The one thing I would say though is there is no date in the bill as to when this is going to be introduced, and it's up to the Secretary of State to do so. So it is there and it is coming, but we don't quite know when and under what guise. It's an aim to give tenants the option to put things right. And under this, the landlord can be compelled to issue an apology, pay compensation of up to £30,000 and repay rent where the service or standard of the property is substandard. So it does have some teeth, and the decision of the Ombudsman will be binding on landlords, and if they fail to comply, there will be sanctions. The aim of this is to try and prevent courts from being bombarded by these type of claims, which can be dealt with by the Ombudsman. So that's that scheme coming in. And the next thing that is currently mentioned in the bill, but again, we don't know when it's coming in and under what guise, is the private rented sector database. It's a creation of a database for the private rented sector, and it's meant to be a one-stop shop for landlords, allowing them access to relevant guidance and to ensure that they know what they need to comply with and what their requirements are. And for tenants, it's meant to increase transparency and making information available to make them an informed decision before their tenancy and during, and allows them to know when they can escalate matters to the Ombudsman or to court if need be. It's also meant to help the councils to know which landlord is doing what, which ones might be rogue, which ones are subject to any convictions or prohibition orders or improvement notices. But the one thing I'd say about that is they just need to be careful as to what information is public on there because of data protection. There will be a 28-day grace period provided to register existing properties, so you will have time to get your ducks in a row. But once the implementation of the bill has come in, you have to sign up in order to be able, you have to sign your property up in order to be able to let it, otherwise you're in breach and potentially subject to a fine. So again, that database is coming in, but we don't quite know when. Okay, so I'm nearly there. Other considerations. One thing that this bill does not cover is private rented student houses. Well, when I say it doesn't cover it, it doesn't carve them out. So arguably, student private rented properties are covered by these regimes, meaning periodic tenancies, you can't get Section 21 to get them out, which to me doesn't really fit the student rental market, because normally tenancy is agreed long in advance, tenant stays for their academic term, landlords get them out, and then they get new tenants in. What happens if a tenant just decides, oh, actually, I quite like this city, so I'm just going to stay in it for an extra month after my degree is finished. Well, that doesn't really help, because if you've got new tenants wanting to come in, you don't then have the ability to get them out as easily. So we just need to be aware that if they more consideration needs to be given on students, and I think this is going to come out when the bill is discussed in greater detail. So I think keep an eye on that one. Although it applies and it could cause problems, we just need to be aware that potentially might be subject to review going on further. You may be pleased to hear that the bill does not currently include requirements to comply with gas safety certificates, EPC and how to rent guide, which you have to do for section 21s at the moment. The bill is silent on those things at the moment, which is landlords might breathe a bit of sigh of relief not having to deal with the gas safety that was relevant at the time the tenant moved in. However, I think it's unlikely that these are just going to go by the by and be forgotten about, given that there's been so much change over the last couple of years to include these requirements. I don't think the government are just going to let them go. The explanatory notes about the bill talks about wanting to bring back in gas safety and electrical reports, but potentially they're going to bring these back in by the private rented database, but we're not entirely sure how they're going to do it. So just keep an eye on that one. I wouldn't say be cavalier and completely forget about them, but just keep in mind and keep up to date with them, because at some point we're going to need them. We just don't know when. But the bill, the notes are specific, don't even mention EPC and how to rent guides. But again, these might be documents that a landlord has to upload onto the portal, so a tenant can then see those documents in advance. And the other thing that landlords need to be aware of, and I've kind of touched on it throughout the talk, is that there is so much enforcement action now that local authorities can take on landlords for failing to comply with the bill. So it is daunting. There is a lot to change, but also landlords need to be aware of these changes to prevent enforcement action being taken. And that's, you know, where there's help and advice needed. If landlords are unsure, they need to kind of step up and start addressing the problems before they become a problem when the local authority become involved. So that's just something landlords need to be aware of, that they are under a lot more scrutiny. Okay, I've kind of covered this again, when the bill will come through. Well, the bill is currently going through the House of Lords and the House of Commons. It's got a long way to go. It's only on its second reading, I think. It's unlikely to be implemented before spring of 2024. And again, I can't guarantee that. It might come in earlier, but it might also come in later. But it's going to be in 2 phases. Phase 1, 6 months after, all new tenancies will be covered. 12 months after, all tenancies will be covered. So landlords will have time to get up to speed on certain issues and give help. And that's why I'm here to give help and advice to get you up to speed and get your documents in order and to get everything going. I'm planning on doing another session like this once the bill is in its kind of final stages, nearly coming out, so we can kind of have a better idea. We can focus on what has changed, what hasn't changed, and what is actually coming out. So just keep an eye on that. I'm just going to see if I've had any questions raised. Someone's raised a question about leasehold properties. Would a prohibition on pets in the head lease be considered a sufficient reason to withhold consent on a pet request? They have touched on that, but what they're potentially saying is you need to then look at the consent from the superior landlord and whether potentially that could be deemed to be unreasonable. But I think that would be, at the moment, I would say that would be a good reason as to why a landlord could unreasonably refuse consent, because you would then be in breach of your lease. But again, there's no clarification on it, but I would suggest that you being able to point to a breach that you would be creating if you let them in with a pet should be considered as one of the reasonable reasons why you're not letting it in. So that's that. I've just had some more questions. Bear with me. I'll just see if I can answer them quickly. Oh, there we go. Does the bill give more rights to tenants who are on an intermediate rent that were previously on an AST? I don't know on that one. I think that's something that we're going to have to be aware of. It's aimed at giving tenants more rights generally, and taking away that, and giving them power and taking away the ability of a landlord to be overarching and dictate what goes on. But the rent increases therefore are aimed at making it fairer for tenants and harder for landlords to increase it. But if you've got any other questions on that point, then do email me and I'll see what I can do. Please can you expand on section on tenancies over 7 years falling outside the regime? Yeah, so if you wanted to grant a fixed term tenancy of over 7 years, so say 8 years, for example, the bill, they will not be an assured tenancy. So this regime will not apply. So dependent on the type of tenancy you create, I don't think we've gone as far as working out what you would then have, potentially a common law tenancy, or looking whether that then means the long leasehold, only at 7 years, 8 years. We have to see, but yeah, arguably they've carved out 7 years and above. So anything you grant a 9-year tenancy, you've taken yourselves out of this regime. So I think I've answered all the questions. Well, I've tried to answer all the questions that have been asked so far. If you've got any other questions and follow up, then drop me an email. And what I should say, following from the disclaimer at the beginning, if you've been affected by anything or worried about anything that's been raised up in these slides, then contact the helpline or my contact details below. These slides and the recording will be circulated in the next couple of days, so you'll be able to get the slides and my recording. And also, when you close out of this webinar, there is a feedback form, which I'd be very grateful if you can fill out once you do it. So I hope that's been informative for you and given you a bit of a whistle-stop tour. If you've got any questions, then just let me know. But I am here to help. So approach me, and if you need me, I'll be here. All right, thank you very much.